All right, good afternoon, everybody. I see some folks coming in, so I'm going to give everyone maybe until 12:02, 12:01, because I want to respect everyone's time. I know it's a Sunday afternoon. But thank you very much for joining. If you would just give me a moment, I want to make sure we have time for others to join. If you have any absolutely pressing questions, you want to get started on before we officially begin, feel free to ask me those questions now. I will leave enough time at the end for questions, but you're also welcome to just send them through either the chat function, or just ask me now before we officially get started. But I will get started in just about a minute here. So thank you for your patience. All right. I think we have enough to get started. But like I said, I know it's a Sunday. I want to respect everybody's time. So a little bit about me for those of you that may not know me, have not worked with me before. Thank you again for taking the time. On a Sunday, my name is Kripa Upadhyaya. I am an immigration attorney. I've been in EB-5 land, as I call it, since 2009, tail end of 2009, but a full swing since 2010. I have been in the industry for a bit, so I've, worked through and worked with a number of regional centers. I currently serve on the American Immigration Lawyers Association National EB-5 Committee. And so we not only gather information that other attorneys are seeing, receiving in terms of RFEs, denials, trends. So we sort of have an inside view of what's going on from a broad perspective because we have the ability to help other immigration attorneys working on EB-5, help them through some of the concerns they're having. We also train newer practitioners that may not be familiar with EB-5. So I do quite a bit of training and mentoring of other immigration attorneys that want to know more about EB-5 or want to build practices on EB-5. But that's basically what I do. I do both regional center work, meaning that I help investors file petitions with regional centers. I also work with investors that are looking at direct investments and want to do their own thing. Um, the presentation today is really going to be more regional center investment specific, only because that tends to be, even now, at least 90% of potential applicants filing for EB-5 are looking at the regional center option. But if you're looking at a direct investment option, I'm happy to speak with you after this call, or after this webinar, rather. If you have questions, again, feel free to put those through in the chat function. I will leave enough time for questions at the end. If you're more comfortable leaving your video screens off and asking questions, feel free to do that. I'm not going to compel you to announce yourself. All right. Okay. So I'm going to start pretty much at the beginning just because I don't know who's familiar with EB-5 or rather what your familiarity level is with EB-5. So if this is stuff you already know, My apologies in advance. But where we are right now in terms of EB-5 is we are in the post RIA world, and the RIA is the Reform and Integrity Act of 2022. It was enacted March 15, 2022. That is the act which is essentially raised your minimum capital investment to 800,000. It also introduced set-asides. So now we have defined areas that are designated either as high unemployment, rural, or infrastructure projects. And there are a set number of visas set aside for each of those three categories, right? Earlier, it was just you file in a rural, you file in a rural, you file in a high unemployment, you file in a high unemployment. We didn't have set asides, which we now do. The minimum threshold, like I said, is 800,000. Areas outside of rural or TE or high unemployment, defined high unemployment areas, are a minimum requirement of 1.05. The total cost, whether you go with rural or high unemployment, it's going to depend on a couple of variables. But for the most part, you're looking at somewhere in the 920, 950 top end. And that's because if you're investing in a regional center, the 800,000 has to go to the investment, right? Towards the project that you are investing in. It has to go towards job creation, essentially. Regional centers, on top of the 800,000, tend to charge what's called an administration fee or an administrative fee. This is a one-time fee. And if you are in the United States and you are not working with a broker-dealer, then sometimes it's possible to get that completely waived or to get that down to as little as 5,000. But some regional centers I know are charging anywhere between 30 to 90,000, which I don't know too many that are at the 90,000. I do know one that's at 75, but they tend to be between anywhere from 5,000 to, let's say, 70,000. And that's in addition to the 800,000 that you invest that's going towards the investment itself. Attorney fees, depending on who you're working with and what their familiarity is with the program and how long they've been in practice, that can go anywhere from, I think, lowest I've heard is 10,000. The highest I've heard is 35,000. So like I said, there are variables. Um, Typically, you're going to fall somewhere in the 900,000 range, all right? USCIS filing fees was 12,160 for the I-526. That has now been significantly reduced down to 3,675. This literally just happened November 12th after a federal court basically dinged USCIS for increasing filing fees ridiculously high to 12,160 without having done the steps that they were required to do to show how much work was needed and how many hours the officers essentially needed to be able to make adjudications on these cases. And so based on that district court ruling, we are back down to 3,675 as of November 12th. Okay. Current processing times, again, like I say, in big bold font, may change month to month or not at all. Right now, rural projects tend to have priority processing, and we are seeing rurals be processed in as little as 3 months. I think those might be anomalies. Typically, I think anywhere between 8 to 10 months is industry standard across the board. High unemployment used to be 16 to 24 months. I've seen some now high unemployment projects come through with an approval on the I-526E in as little as 6 months, right? So this impacts you in terms of you being able to decide, okay, I want to do a rural, I want to do a high unemployment. There are significant differences in terms of how those offerings are structured, right? Is it an equity? Is it a loan? Are you in first position to be repaid? Is there a mezzanine loan or a senior loan or a bridge loan above you, which means there is additional risk for you in terms of refinancing or getting your money back? Those are things that you typically want to consider. But I do have clients who tell me, I understand that the money needs to be at risk. I just want the green card and I want it as soon as possible, right? And so if you're looking purely in terms of timelines between a rural and a high unemployment project, rural for the most part was getting the benefit in terms of significantly earlier processing timelines. I think we're seeing a bit of a leveling. If you go with rural versus high unemployment, you may still end up maybe 3 to 4 months ahead of schedule compared to a high unemployment, but that difference is no longer as distinct as it used to be. Okay. Um, Again, for those of you that are in the United States, whether you are on F1 student visas or L1s or H1s, what have yous, you have the benefit of filing for adjustment of status, concurrent filing for adjustment of status. Work permits tend to come much quicker than your travel permits. So work permits on average right now are about 3 months from the date of filing, 3 to 4 months from the date of filing. Travel permits tend to take a bit longer. And so those are coming in closer to 8 months from the date of filing. There are some EADs that are languishing, which is why I have that 6 to 8 month. That used to be what we were seeing across the board. But again, USCIS, at least at the tail end of this year, seems to have picked up their processing timelines. For those of you that are under, that are on H-1B or L1, technically you can leave the US after you have filed an adjustment of status because you would presumably be entering on your H-1s. So you have the ability to leave and re-enter on your H-1. Those of you that may have entered on a tourist visa and are now hoping to file for adjustment of status, you cannot leave unless a travel permit is issued to you. There are some options, very limited options for expediting a travel permit based on extreme need, typically a humanitarian reason. But on average, you should fully expect to be what I call prisoner within the United States for about 4 to 6 months from the date that you file. Okay. And for some of you, if you have had, lapsed status, let's say you were on a student visa, your service has now been canceled, but you are still in the US, you can file for I-526, you can file for EB-5, but you're likely going to get stuck with consular processing because you may no longer be an applicant for adjustment of status. So these are issues you really need to work through with an attorney that has experience in these things. But if you want to know what the timelines look like, this is what the timelines look like at the moment. Okay, project selection issues. The first thing I will say is that immigration attorneys cannot, should not, under any circumstances, be recommending one project over another, unless we as attorneys are registered brokers and are registered broker dealers under the SEC, under Securities and Exchange Commission guidelines. Technically, legally, we are not permitted to provide investment advice and to guide clients to any particular project. Any attorney doing that is essentially in violation of their licenses, but also in violation of ethical conduct. There are some attorneys now that have gone out and have become registered broker-dealers. But if you are working with an attorney that is both your attorney but also a registered broker-dealer, I think that is a conflict of interest. So make sure you are asking them questions about, do they represent the project that they are recommending to you? Because if they do, that administration fee is going to the attorney, on top of which they are likely charging you attorney fees, right? So there may be potential for significant self-dealing, and that's not something you want to deal with. Now, historically, because again, like I said, I've been in EB-5 land since 2010, I've worked with a number of projects. I've seen and heard of multiple projects that have gone south or gone bankrupt. And so if you're wondering, how do I select a regional center? These are some preliminary questions, very, very basic, but at least something to help you winnow out one from the other, okay? The things you want to ask: how many projects has this regional center done, and how many projects have they successfully completed? How many prior investors have been repaid? How much time did it take for those investors to be repaid? Can you speak to some of these prior investors? Some regional centers will have a list of prior investors that have agreed to speak to prospective investors. And so you want to figure that out. The biggest thing right now is whether the project is in relevant good standing with USCIS. We've had about probably 2,000, maybe more projects, pre-RIA projects, that were delisted or terminated. And then there was another wave of terminations that came in June of this year. So one of the things that the RIA introduced is that regional centers have to go through this process of due diligence and report every year. that reporting requires regional centers to also pay a significant fee in order to have their accreditation renewed. A lot of regional centers decided either that they weren't going to do it or to take the risk that USCIS wasn't actually going to take action. And so even though they knew that they were required to file these declarations and to pay the fees, they just decided USCIS wasn't going to do anything. And so they blew the deadline. USCIS turned around and terminated something like 1,000 projects. So you want to be very, very careful. If you are a current investor in a project that has been terminated, you need to contact an attorney immediately because you need to figure out what the stakes are for you now, particularly if you are in the US and you have started working on your EAD and you were banking on your green card coming through. If you have invested in a project or you are looking to invest in a project, make sure you understand what the current standing is with USCIS. Project specific due diligence. What is the project, right? What is the vertical? Understand that what a regional center needs to have in place in order to build a condominium is very different from what they might need for a ski resort project or for a senior housing project, right? You want to make sure they have all of the permits in place. Are there any delays? Have you started construction? How long is your construction going to take? Is there a construction guarantee that the developer is giving you? So these are just basic questions to ask. With respect to job creation cushion, the legal requirement, sorry, I can't speak this morning, legal requirement is for each investor to have created 10 jobs for qualified US workers. And the qualified US workers includes US citizens, lawful permanent residents, and certain others that are legally authorized to work in the US. Okay. Ideally, you want a project that has a cushion. They are required to create 10 jobs per investor. You want to be in a project that is creating more, and that more is going to be anywhere, right? It's going to depend on the project. But I have seen projects go anywhere from 12 jobs per investor to 25 jobs per investor when they're only required to create 10. But at minimum, you want to be in a project that gives you a little bit of cushion, that has more jobs than investors, basically. Capital stack considerations, in my opinion, is major, right? It may not be for you. Each client is different, each investor is different. The reason why I think capital stack considerations are major is because you want to understand what is your position in the capital stack. If things go wrong, who gets paid before you? If there's a senior loan, a mezzanine loan, they're going to get paid before. If the investor has gone out and got a bridge loan because they didn't get enough financing, how does that affect your position in the project? Historically, for me, I have tried to create a portfolio of projects where investors are in first position to be repaid. Those are the ones that I do due diligence on and present to investors. The investor finally decides which one they want to select. I will not tell you where to go. But if you're asking me for recommendations or referrals to projects, my tendency, if you will, is to give you projects where you are in first position to get repaid because I think that makes things a lot more secure for you in terms of receiving a return on investment, right? I mean, I was losing sleep when this thing was at 500,000. Now it's at 800,000. It's enough to keep me awake at night. Do not want a failed project on my conscience. So I will do all of the due diligence that I need to do to make sure that my investors are being placed in projects that have a really good track record. Understand the exit strategy. What is the end that this project has in mind, right? How do they plan to repay investors? 95% of the projects will tell you we will either refinance or sale or have a sale of the asset. Okay, well, if they are going to refinance, what performance metrics do they have to meet in order to hit that refinancing minimum, right? Because you always want to refinance at a lower threshold, obviously. So then what are the performance metrics that have to be met? If you're a hotel project, for example, or if you're looking at a hotel project, typically a hotel project will need to have a certain room per rate night that they meet, as well as an occupancy rate that they need to meet, right? So what are those metrics? If you don't meet those metrics in the first 2.5, 3 years of the project, what does that mean for investors? These are all questions you need to be asking before you wire the funds. If you care about the return, right? Assuming that you care about getting the 800,000 back. All right, now moving on to source and path of funds. This is the most crucial part of your I-526 EB-5 application. Your EB-5 at the conditional green card stage, right? So the first stage is getting your conditional green card. 95% of applications that are denied at the conditional green card stage are denied because there was an issue with respect to the source of funds. USCIS holds EB-5 applicants to a preponderance of the evidence standard, meaning have all of the documents that you provided to USCIS give an officer at the IPO more than enough faith and confidence in your application to understand that the money was legally earned and the money was legally transferred, if the money was coming from outside of the US. Okay. The other thing when you are doing your project reviews is to also ask the project if the regional center provides a return of funds guarantee. If your application is denied at the I-526E stage, the conditional green card stage, because of a failure, if you will, to provide adequate documentation on the source and path of funds, is the regional center going to refund the money? Most regional centers, at least every regional center I work with, has that guarantee. They have a source of funds denial guarantee, but you want to understand how long is that going to take. For some regional centers, that's immediate. For others, 90 days. For some others, 120 days. But you want to understand what that means. The new trend right now is USCIS is denying applications at the I-829 stage, which is the end stage where you get your permanent green card, if they feel that the original I-526 approval should not have been approved because there might have been some lapses in the source of funds documentation. So again, when I say the source of funds is an absolutely crucial part of your application, it is because it is an absolutely crucial part of your application. And if you are working with an attorney who tells you they're going to help you with the application but expects you to create your own source of funds report, you are not being well served. I will say that as blatantly as I can. You are not being well served if you, as a non-lawyer, is expected to create your own source of funds report. All right. We'll talk about this a little more, but this is a new thing that has propped up maybe in the last 3 or 4 months. A lot of regional centers were doing two things, or some regional centers were doing two things. One was a regional center backed loan, right? So some regional centers had this model where if you invested, I think it was 300,000 or 500,000, they would give you a loan on the remainder. USCIS has started denying those outright. And the reason for the denial from USCIS is that if a regional center is acting as a bank, then they have to be FDIC insured, right? There are banking rules that are both federal and state. You cannot be a real estate developer or a commercial developer, which is most of what these projects are, and then also decide to function as a bank. That is not legal. And so a lot of investors that had received loans from the regional center are facing denials right now and have received denials. There are also denials or requests for evidence coming in for applicants that used SDIRA loans, so self-directed IRAs. Now, SDIRA is very, very new, first of all, to the EB-5 marketplace. I think this only came up probably 2023 or even 2024, right? As late as 2024. This is not something the IPO or the Immigrant Program Office is used to seeing. And they have shown that they don't like this model. They don't like the STIRA model. They don't like regional center loan models. In fact, they also don't like partial investments right now. So we are seeing a significant spike in RFEs, even for projects that where the investor is investing the full 800,000, but it is an installment plan that is longer than a year, right? They seem to be tolerating plans that are 6 to 8 months. But anything more than a year, it's raising significant issues at IPO. So again, when you are investing to the extent that you can invest with the full 800,000, if you can't take the risk and do the installment plan, but keep that under 6 months to the extent that you can. Make sure you are fully vested within 6 months. Okay, what can you use in terms of your source of funds documentation? You can use anything that is legally documented or legally documentable, right? So Salary either for yourself or for your parents if your parents are giving you a gift. If it is a gift, there needs to be a gift deed. The giftor ideally needs to provide his or her tax returns to show where and how they earned their money. If the money was transferred into your account, which obviously it would have been, you need to provide bank statements showing the incoming wire transfer into your account. CDs, FDs, anything that you had, 5, 7, 10, 12 years ago, if you can document that, great. RSUs, perfect way to show if you are working with investment portfolio, any RSUs that have vested, to the extent that you are doing an installment plan and you have RSUs that will vest in the next 3 months. Let's say you're on a payment plan that takes you to June and you have a bonus coming in January, maybe performance-based bonus, and you have some RSUs that are due to vest February and March, you should, or your attorney rather, should include that in the source of funds report to show where that 800,000 is coming from, right? Part of the source of funds report requires you to show down to the penny the full 800,000 and where it's coming from. And so if you're saying I have, a significant performance bonus and I have some RSUs or ESOPs that I can liquidate January, February timeframe, then you really should provide documentation of that as part of your source of funds report. Okay, if you own a business, even if you are 100% owner of the business, you cannot transfer funds from your business account. It needs to go into your personal account. You need to claim that as personal income, whether that is a performance bonus, whether that is disbursements, distributions, what have you, is based on, whether you are a flow-through CL, pass-through PLLC, whether you are a LLC, whether you are a C Corp. If there is money in a business account that you have the right to take, baby, because you put in capital and now you want it back. You gave your own company a loan and now the company is repaying you. There's all of this profit sitting in the company accounts that you haven't claimed. It cannot go directly from your corporate account into the EB-5 investment. It has to flow through you as a person, individual, through your personal account. Now, if you are using business income, you also need to qualify the business, right? So corporate documents, articles of incorporation, partnership agreements, tax returns, if you have them, audited financial statements. How long do you need to go back? Depends on how long it took for your business to show a profit. You cannot tell me, and I'm saying this because I've had this situation, you cannot tell me that you are a business owner of a very successful tech company that earned $1 million and you're going to take 800,000 out of that million for the last 3 years, right? So you have 3 million in profit and you're going to use 800,000. And when I look at your tax returns, those are not the figures that I see. You're not filing for EB-5, at least not through me. I'm not interested in working with somebody who's going to waste time and energy on their part and mine and end up with a denial. It's just not worth it. The risks are too high, right? So understand that yes, you can use business income, but there are certain steps you have to go through to make sure that you are showing that the money was earned by you. You can take a loan from the business. That's perfectly legitimate. You can take a loan from the business. If you own 75% of a company and there's money in the company and there are profits that you have a right to, you can take a loan from the company and say, for example, I'm going to defer any disbursements that would be due to me 2026 or 2027. The safer thing to say is maybe I will take 50% of my salary because disbursements depends on how the company does any given year, right? And so that is more fluid, which USCIS might not like. They like to show exactly where the money came from, or they like to see exactly where the money came from. So if you're planning on using corporate funds, if you own a business, yes, you can, but there are a bunch of steps you're going to need to go through. Sale of real estate or HELOC, absolutely possible, but understand again, if you are using HELOC for property that you own, then you have to show where did the money come from to purchase the property in the first place. The genesis of the funds, the corpus of the funds has to be legally earned, legally transferred if it's coming from outside of the United States. And then, again, if it was property that you inherited that you received via inheritance, then there will be trust and estate documents that you will need to provide. If it was property that you were gifted, then again, there will be gift deeds. If there was gifted property, whether that's in the US or whether that's in India, there may have been tax considerations. Any other part of the world, there may have been tax considerations. So you will need to provide documentation to show all of the legal paperwork surrounding inherited property, gifted property, any property that may have been the subject of litigation. If you were awarded that property by the court subject to a litigation, you need to provide those documentation. All right, to the extent that we have anybody that is from India and has property that is part of the Hindu undivided family or half, I'm already holding my head as you can see because I've had to do several of these. They are supremely complex. If this is the route you want to go through, make sure you are working with an attorney that understands Huff and how they are structured, what the purpose of a Huff is, because there are special tax privileges for Huff, which is really the only reason I can tell why people enter into them to begin with. The problem, not the problem, but the most complicating factor with Huffs is that it is never owned by an individual, right? You need multiple people to be part of the Huff estate. And so if it is property that belongs to three or four people, the basic thing for you to document is how did this property come to you? Did the others provide a quitclaim deed? Did they gift their share of the Huff to you? What happened so that you now became in possession of the Huff? All of that needs to be documented. Each step in that process needs to be documented. Oh yeah, the other thing. I have a lot of people that call me that say, "Oh, I bought property in India and I want to sell it, but the seller is only willing to give me 50% cash." USCIS doesn't understand black and white, okay? Everything needs to be documented. If you're telling me you sold a property for the equivalent of $1 million, but you can only document 500,000 US, you're going to need to come up with a second source of funds that is documented for where you got the 500,000 from. USCIS does not understand circle rate versus tax rate, black and white denominations. So keep that in mind. Okay. Gift as a source of funds, I think I've already gone through this. Essentially, yes, you can take a gift, does not matter where or in what country the giftor is. There may be gift taxes that apply based on the tax regimes of whichever country that person is based in. There needs to be a gift deed showing very clearly that this was a gift. It can be for the full 800,000 or more, does not matter. The other question that I get sometimes is, can I take multiple gifts? Can I get a gift from my uncle, an aunt, a cousin? Sure, you can get multiple gifts as long as each one of those giftors is able to show you where his or her funds came from, and there is a legitimate gift deed, in line with any taxation issues that may come up for the country in which that person is a citizen of. Okay? Path of funds. In addition to the source of funds, you also need to be able to document the path of funds. How did the money go from wherever it is currently cited, whether that is a bank account in the United States or outside of the US, into your bank account, and then how did it go from your bank account to a regional center account? So if you're in the US, H-1B, L1, whatever, and you have a bunch of money in a Bank of America, a Wells Fargo, a some sort of brokerage, whether that's Charles Schwab or, Robinhood or whatever, you're going to need to show what USCIS refers to as accumulation of the funds, right? So the money, ideally, you want that 800,000 coming into a particular account, and then you have to document all of the ways in which that money got there. So I got 100,000 from my primary checking account, which is where all my salary was deposited. I took 100,000 from there and I put it into this account. Then I had this much in savings. I took it out of my savings account. I put it into this account. Then I liquidated my RSUs or ESOPs. Those came into this account, right? So you need to document that path. If you are a Chinese national, Chinese resident, Indian national, Indian resident, it's going to take you much longer to get money out of any of those two jurisdictions, China or India. China has a limit of 50,000 renminbi unless you are sending money out of Hong Kong or Taiwan or Singapore. If you are a Chinese national and you have PR in Singapore, then you can send out as much as you want. If you are a Chinese national in Hong Kong, you can still send out as much as you want. Chinese nationals within mainland China, you are restricted to 50,000 renminbi per year. Same thing with Indian nationals inside India. You are restricted to 250,000 in a given fiscal year. Fiscal year for India is going to change March and April, right? But if you are trying to get money out of India and you are an Indian resident, then understand that there is a restriction of 250,000 Indian rupees per fiscal year. Plus, there is now a 25% TCS tax at origination. So you have to pay, let's say you're trying to take out 400,000 out of that 800,000 that you need. You're going to need two people because one person will take out 250, the other one can give you, the remainder. But each of those two transactions will incur that 25% TCS fee. That TCS can be claimed, I think, at the end of the tax year as a refund, but you still need to pay that 25% at origination. If you are an Indian citizen, non-resident Indian, then your limit is $1 million. And you can use your NRE or your NRO accounts to make that transfer. There is no limit on NRE and NROs. But again, the reason why I'm going into this a little more than I normally would is to impress upon you how complicated this is. This is not something that, surprise, surprise, we are taught in law school. So this is really something that attorneys spend a lot of time learning and becoming competent at. I would not even say an expert at. I've been doing this since 2010. I am nowhere near anywhere close to being able to call myself an expert on these things, but I have worked on these for several years where I know what to do and what to look for. But this is why you need to work with attorneys that understand source of funds for specific countries, because it's getting to be very difficult with the IPO. To the extent that you are doing a currency swap, honestly, my recommendation right now is to the extent that you can avoid it, avoid it. What is a currency swap? Very common with Chinese national investors because of that currency restriction or remittance restriction. If you have, let's say, a cousin in China or India, and your parents will give them 400,000, and then a cousin in, Hong Kong or somewhere transfers you money, and then a cousin in the US gives you US dollars equivalent, that's a currency swap, right? Um, each person in that link is going to need to provide their financial documents or an affidavit. And once you open that box for the IPO, they're going to go through it with a fine-tooth comb. You are significantly increasing the possibility of you getting an RFE, a request for evidence, if not an outright notice of intent to deny. So again, because I'll say the one thing that I tell all my clients, because you have 7 possible options for how you can come up with the 800,000 does not mean you use all 7. This is where expertise and familiarity of the attorney becomes crucial, because the idea is to get you to use the 3 or 4 that still get you to 800,000, but get you there without significant risk of a request for evidence or significant risk of a notice of intent to deny. Okay. So just because you have 7 options doesn't mean you use all 7. You stick to the ones that are quickest, easiest, simplest to prove. Okay. I've already said source of funds is a crucial element of your work. If you are required to do this or expected to do this work by your attorneys, my apologies, you ended up in the wrong hands. I mean, seriously. But there are a couple of things that you need to understand. The source of funds requires the investment be traced to a specific source. You have to present the evidence in sequential manner. You can't just throw them in there and say, it's all here, go have fun, review it. I mean, when I write these, my source of funds are anywhere between, I don't know, 15. I think the longest I've done is about 30 pages. We have Excel spreadsheets, charts, visual aids, color-coded, boxes and various charts to help an IPO officer look at it and visualize it and say, okay, this is what I'm looking at. The IPO is the Immigrant Program Office that is a part of USCIS, and that office has exclusive adjudication authority over all EB-5 applications. Those officers are trained. They are trained to spot money laundering. They are trained to spot Hawala money coming into the US, right? Illicit pathways coming into the US. But they only have maybe half an hour to review what tends to be a 5 to 8 inch submission. Try and help them to the extent that you can. I promise you, it's only going to make it easier to get approvals out of the IPO officers. Okay. Um, Possible retrogression. So looking ahead to 2026 and where we are. The December 2025 Visa Bulletin does not, as of yet, show a backlog. So for those of you that are in the US on valid status, whether that's F1 or H1 or L1 or what have you, you have the ability to file for adjustment of status concurrently with your EB-5 applications. There is no retrogression at present. The reason you're hearing about retrogressions is because, again, as you see on here, there is what we call a hidden backlog, right? And what that means is that from 2022 to July 2024, we had a total of 6,506 I-526E petitions filed. Some of these have been approved, some of these have been sent to consulates for processing for people that were not in the United States. But we have 51% applicants from China and 20% applicants from India. And for those of you that are stuck in 10, 12, 15-year EB2 lanes, hopefully you understand what this means. The US immigration system is such that no country can get more than 7% of the total number of visas available. So if there is already 51% applications from China and there is already 20% applications from India, we've blown through that 7% a long time ago. Right, so that's what that hidden backlog means. It's not reflected in the visa bulletin, but there are enough applications at USCIS for that threshold to be met. USCIS and the consulate. Now, why have we likely not seen it actually reflected in the visa bulletin? Couple of issues, and I will only talk about my own experience here. Some of my clients applied for EB-5 but ended up getting their EB-2s or EB-3s because they had applications that were filed who knows when, right? 7, 8, 9 years ago. My most recent client, we filed an EB-1 for him as an international business owner, international executive, but the EB-1 ended up coming in faster than the EB-5 that we had also filed for him. He wasn't very confident about the EB-1, but I was able to get that done for him. So because he had the EB-1, we didn't need the EB-5, so we withdrew that. There are a number of withdrawals of filed but pending applications. It could be changed priorities, changed circumstances. Somebody got married to a US citizen, no longer needs the EB-5, withdraw it. Somebody decided, forget it, done with the US, I'm moving to Canada, withdraw the EB-5, right? So some of those applications that were filed at USCIS may no longer be going forward. The other issue is there are some consulates where it's taking a lot longer for applicants to get to the visa interview. Abu Dhabi, for example. Abu Dhabi right now has close to a 15-month wait after USCIS approves the application, right? So once USCIS approves the I-526E, they send it to the US consulate. Mission India used to be, I think, at about 15, 16 months until early this year. They have now brought that down to about 6 months. So Mission India is actually way ahead of Abu Dhabi. Abu Dhabi is currently at about 15 months. Now, in that 15-month time frame, again, priorities change, people make different decisions, and so we haven't actually seen the backlog get reflected. That does not mean that there isn't a backlog coming. It's likely still going to come, but again, it's not coming in December. So use this time to the extent that you can and you have the resources available to file for adjustment of status because, again, the longer processing time at consulates is a significant advantage for those of you filing for adjustment of status because you don't have that same backlog, that same processing timeline as some of the foreign-based applicants do. All right. The other major issue that's coming up in 2026 is the sunset of the RIA. So there are a couple of things that are currently fueling what I call a mad dash to EB-5. One is the AI tech job losses, terminations, that's been leaving employees feeling very, very unsettled, and they want something that they feel like they can control as a part of their immigration journeys. And so I have a lot of clients that are opting into EB-5. because they don't trust that the H-1B is going to be available, or they don't want to be, caught unawares the next time there's a termination that comes around. So that's one. The other is, and this is significant, the Reform and Integrity Act is due to sunset. So EB-5 programs are generally authorized for a 5-year period, and that 5-year period for us is up in 2027. But the RIA has a grandfathering deadline for investors of that is September 30th, 2026. The grandfathering protection basically states that if you are an applicant for EB-5 and your application is received, receipted at USCIS, not approved, just received and accepted, receipted at USCIS before September 30th. If Congress decides, okay, it's no longer 800,000, it's going up to 1 million, your application continues. If Congress decides, okay, new applications as in after September 30th now have to create 15 jobs instead of 10 jobs, you still have the benefit of 10 jobs because you are grandfathered under the existing RIA as of September 30th. So, to the extent that you want the protections that we had fought so hard for in the RIA to apply to you, then it is in your best interest to make sure that you do what you need to do so that you can file an application for adjustment of status and, more importantly, I-526 before September 30th. And when I say September 30th, please, let's not have a repeat of the last time EB-5 went away, 2018, where I literally had applicants calling me the week that it was going to be no longer available, saying, I'd like to file for this now. And these were individuals I had been speaking to for maybe 3 months, and they had not made a decision on which regional center to select. And all of a sudden, the week that the program is going away, they decided they wanted to fund their investments. So don't make that mistake. Again, you know the deadline is September 30th. Try to make sure that your applications are in well before September 30th. The other major disruption, if you will, is the Trump Gold Platinum cards and how that impacts EB-5. So first thing first, the Trump Gold Platinum, whatever version they care to subscribe to, is not the same as an EB-5 application. It is not the same program. It is also, most importantly, only a proposal. It has not been enacted as law yet. So yes, there is a new website that was unveiled, I think a week ago, which shows a gold card with the president's face on it and tells you you can now pay the $1 million by credit card. So for those of you that have a spare Amex Black lying around under your sofas, that's apparently an option. You can pay the $1 million by credit card. The requirement is $1 million for individuals or 2 million for corporation on behalf of an individual. Again, like I said, it is not the same as an EB-5, and the main reason for that is this is a gift. You do not get that million or 2 million back. It is a gift to the US Treasury for the US Department of Commerce to decide how best to utilize it. Applicants would be placed in the EB-1 or EB-2 line for a green card. So for those of you that were born in India or China, you are already going to be facing a backlog, right? So if you are an EB-2 and you want to apply for the Trump Gold or Platinum card, you're essentially going to be at par with every other EB-2 perm, NIW perm. And if you want an EB-1, there is already a backlog for India, which is 4 years long, and a similar backlog for China. So you're starting at a disadvantage compared to a standalone EB-5, all right? As of now, again, because the specifics of the program are still being worked out, I suspect, I don't know that there is a job creation requirement. I haven't seen anything that says job creation is required. And I'm going to tie this back to what I said earlier. If you are a business owner that has money in your business, but you do not own personal access to those funds, or those funds have not been transferred to your personal account and you don't want it to be transferred to your personal account, this may be an option for you because it allows a corporation to file on behalf of an individual, right? So if you own 100% of your company, then waiting for more information on a Trump Gold card so that your company can file for you because you don't want to have to take the tax burden, that may be an option. It is not yet law, so you might want to wait for that. There is likely going to be an impact on EB-5 because, again, like I said earlier, we only have the one IPO, right? The Immigrant Program Office. And yes, the IPO is functioning a lot better now and they're doing a really good job. But there was a time when there were something like 15 officers at the IPO and that was it. So if there's going to be this new program, we already have a bunch of EB-5s going in. There are already a bunch of I-829s, which is the removal of conditions for the permanent residents based on an EB-5 investment. Now you add the Trump Gold and Platinum card on top of that, and you have a core of maybe 50 people at IPO that have the ability to work on these applications. We're probably going to see longer adjudication times for I-526. So again, as of now, this is not the law. This is only a proposal. But if you're asking me how does this impact EB-5, it's more likely than not that it's going to sit alongside an EB-5 instead of replacing it. But it's going to impact EB-5 because the processing time is going to be longer because officers now have a whole new category of application type that they need to spare time working on. All right. So the two big things for 2026, three. One, possible retrogression. Two, sunset of the RIA that's going to impact EB-5 investors directly. And three, indirect impact on EB-5 from the Trump Gold or Platinum cards, right? So those are the three main issues for you to keep an eye on. All right, which brings me to the end of my prepared comments, if you will. This is a little bit about me. I have added my legal assistance information here. Her name is Akiko Owens. If you want to schedule time, if you have questions about EB-5, feel free to contact Akiko. She can set up time for us that works for you. For now, I am going to stop sharing my screen so we can go to any questions that anybody might have. All right, let's see. I have two questions on here. I am new to EB-5. Can you give a brief overview of the other option apart from regional centers? Yes. So the other option apart from regional centers is for you to invest either 800,000 into your own project as long as it is sited physically in a rural or high unemployment area. So for example, I have an investor who invested in a dental clinic in a high unemployment area. And we were able to do that investment for 800,000 because it was a high unemployment area and the dental assistants were going to come out of that immediate vicinity, right? So you can invest in a high unemployment area at the 800,000 level as long as your business is going to be sited in a rural or high unemployment area and the economic impact is going to be to that area. Otherwise, it's 1.5 million. Okay. If RC only gets 50% of investment as first payment, how does that money disperse back to EB-5 investors? Does it go to first 50% investors? That depends on the regional center. But that's not a project I think anybody should invest in, very honestly, because what you're telling me is if they only get 50% of the investment, how are they going to be fully capitalized? How are they going to create the rest of the jobs? How are they going to replace investors, right? That leaves me with more questions that personally, again, not a broker dealer, but my personal opinion on that would be probably best for you to not invest in that investment or in that project. Okay, if dates retrogress and then I file, will I get an EAD? No. In order to file for adjustment of status, visas have to be immediately available. In that, visas have to be available as of the date that you file the application. So if there is already a retrogression and then you are filing your application, you can only file the I-526, the EB-5 application. You will not be able to file the adjustment of status. The adjustment of status application is what gives you the work permit and the travel permit, the EAD, and the travel permit. So if you cannot file for adjustment, then that's no longer an option. You will only be able to file for the I-526E. Okay. All right. Another question here is, can we use balance transfers as source of funds if my credit card limit is very high? I'm not sure I understand this. You can't pay an EB-5 investment via credit card. That's an option for the Trump card, apparently, not the current EB-5. So you may have a high balance transfer unless your credit card allows you to take a cash advance, and you're planning on using that cash advance against your available balance, then yes, because you're still getting cash. That cash then can then go to the regional center. In your source of funds, you would likely then need to provide documentation to show how you plan to pay back that advance because that's essentially a loan, whether it's Amex or Visa or, whatever high value credit card, that is still a loan to you, right? Because it's an advance on your transactions. So yes, you can probably do a cash advance, but the EB-5 investment requires you to make a capital infusion, which cannot go on a credit card. All right? Okay. Any other questions? Because I think that was those. Oops, there's new ones coming in. Okay. Infrastructure projects have less applications from USCIS statistics. Would that be a good option, considering so many people are behind if a possible retrogression happens? Possibly, but again, you want to review infrastructure projects and make sure you know what it is that you're getting into. I am only aware of maybe two infrastructure projects that are available in the marketplace right now. One is based in Oakland, California. The other is, I think, Texas. But there are only two infrastructure projects. There may be more coming into the market now because also, again, infrastructure projects did not exist pre-RIA, right? That's something that the Reform and Integrity Act introduced, and a lot of regional centers just haven't found appropriate projects. And also, infrastructure projects tend to be a lot harder to exit out of. Again, you're looking at either most regional centers, 95% of regional centers. The exit strategy in terms of how to repay investors is going to be sale of the asset or refinance the asset. It's typically harder to sell or refinance a true infrastructure project, right? And so there are just very few that are available in the marketplace. And so, yes, if there is to be a retrogression on rural and high unemployment, then an infrastructure project probably saves you from the prospect of retrogression. But then you also want to look into the metrics in terms of refinancing and repayment of your funds and how they plan to do that. Okay. All right. Any other questions? Feel free to just ask. Okay, there's a new one. Give me a second. I'm trying to get to these as quick as I can. What type of projects are my clients using? Everything. Everything in the kitchen sink. A lot of my clients, like I said, I have some clients that prefer to do directs, so I'm helping a lot of people do directs. So, like I said, I've done dental clinics, I've done um life insurance brokerage companies. I've done a tech company from the ground up on direct projects. I have investors that will choose rural, and I have investors that will choose high unemployment. It really depends. For my clients, it depends on what countries they're from and also what their needs are. I have some clients that are, in Singapore that have children that are maybe 11, 12, 13 at most. And these kids are in either American school or British school and they want to come to the US for college. And so the parents are thinking way ahead and investing in an EB-5 now with the idea of the kids coming in much later. So for them, high unemployment makes sense because they don't need the EB-5 in the next 5 months. But if I'm looking at somebody that's in the US on an H-1B, probably a rural, just because the processing timelines up to now have been significantly better for rural projects than for high unemployment projects. Okay. Um, as investors, are we supposed to find regional centers or do EB-5 lawyers connect us with regional centers with active projects? You're not meant to find regional centers. I mean, I will tell you my process, and I don't know at what point you joined the presentation, but I have been in EB-5 land, as I call it, since 2010. So I know of projects that have gone bust. I know of current regional centers that have been sued by prior investors and prior business associates, and I know of current regional centers with failed projects. So am I able to give you historical data about different regional centers? Yes. Am I happy to refer you to regional centers where my prior clients have invested and tell you what their experience has been, and then also look through the PPM and advise you on what, some of the more stringent risks are for regional centers, yes, but I will not decide for you, right? So I will give you the information. I will arrange phone calls, video calls, Zoom calls between you and the regional center so they can give you the information. I typically sit in on those calls, not because I don't trust them. I just want to make sure that you're not getting information that is different from what was provided to me. So I typically will give my clients 3 to 4 regional centers and 3 to 4 projects. And if you want a mix of high unemployment versus rural, let me know. I'll put those in rotation. If you want high unemployment, rural, and infrastructure, great. We'll put those in rotation. My team is regional center agnostic. We represent clients. We're very clear about that. I don't represent regional centers. I don't help set up regional centers because I think it's a conflict of interest. I work with clients. That's what I do. So, no, you're not expected to find regional centers on your own. But that being said, if you know of a regional center, your friends have told you of a regional center, I'm happy to review them for you if that's what you want. Um, okay. End-to-end process from investment options to exit strategies. I think we covered that on this at this session. I know I talked about it quickly, but I know I talked about it. If you have any follow-up questions, feel free to get a hold of me, and we can go through, exit strategies. Most of the time, again, like I said, it's going to be either refinance or exit. The thing that's different is the capital stack, right? And okay, I want to be respectful of people's times. It's 1 o'clock, and so we are at the 1 hour mark. So if anybody needs to leave, please feel free to do so. Um, Let me just see if I can quickly share this screen only so you have my contact information. Actually, where is Akiko? Here we go. I'll leave this up so you have the contact information for my assistant, but that's there. But again, what's different for different regional centers is it a loan model or an equity model? Most regional centers currently are offering a loan model. Loan models are very, very popular in in rural projects. There are some equity models that are in high unemployment projects, right? Or high unemployment projects that are equity model rather. So you have either loan or equity. Rural, high unemployment. The way the projects are structured are going to be very different between one versus the other. The thing that's very different also is the capital stack. Again, are you in first position to be repaid? Is there a mezzanine loan, or a senior loan above you? Anytime there is a mezzanine loan above you, I don't care what the regional centers say. And again, like I said, I'm very clear. I'm agnostic. I don't play favorites. There are some regional centers that drive me insane when they say things like having a senior loan is really good for our clients because that means another bank really likes a project and they want to be a part of it. What they're not telling you is if that project goes south, that same bank that is in the senior mezzanine position, they're going to get all of the money first. Investors are going to get what's left behind. You need to understand what the capital stack is, right? So figuring out the capital stack, figuring out what is the percentage that you are being paid. Some regional centers are 0.25% all the way up to 5%. And then how long are they holding your money? Some will say 3 years, but once you read the fine print in the PPM, there's an option for them to exercise so that they can extend the life of the loan for 2 additional years, right? So you may go in thinking it's 3 years, but it's actually 5. Or you go in thinking it's 5, but it's actually an option for 2. So it's 3 plus 2, 5 plus 2. What is the amount of time that they are going to hold your money? That's something that you need to understand. So again, I will say this again. If you are new to EB-5, you need to be working with somebody where you can build a relationship with that attorney so they can spend time helping you understand the landscape. They can help at least identify some projects for you to look at as a beginning. Um, and then you make your decision, right? You decide which project is best for your risk appetite and for your needs. Don't let the attorney guide you one way or the other than giving you the information and telling you this is what's out there, these are your options, and then you decide. Okay. Um, all right, just to protect everybody's privacy, I am going to stop sharing because I need to be able to see what's on the comments, and I don't want people to see who's asking those. So give me 1 second here. Again, if you would just take down my contact information and also Akiko's if you want to follow up. I would ask you to please email her so she can coordinate with you for your availability and then schedule Zoom calls or phone calls or in-person meetings. I am in Seattle. So for those of you that are in Seattle, Bellevue, Redmond, whatever, we can always meet in person if that is what you prefer. All right. Oh boy, whole bunch of questions. Okay. Give me a second here. I am falling a little behind. Okay, payback guarantees from builder mean anything unless loan is on their property. How does this guarantee of payback work on legal grounds given project owner signed papers on return guarantee? Depends on what they're telling you, right? So there is a project in the marketplace, a regional center in the marketplace that has a loan repayment guarantee from the builder, and the builder is a fairly prolific builder with $30 million or $30 billion asset, right? They have $30 billion worth of assets. So if the builder is giving the regional center a money back guarantee, what that means is that the if the contract between the regional center and the builder is 5 years, which takes us to 2030, right? So let's say January 2030, builder is meant to pay back the regional center all of this money, and they don't. The regional center gets to either claim the asset or sue the builder to return the money so that the investors can get paid back. That's what that means. You want to be careful about, or not careful, but at least understand anytime when there is an integrated, vertically integrated development, right? So the developer is also the regional center because clearly the developer is not going to sue themselves, right? And so in a vertically integrated regional center structure, you want to make sure you're speaking with former clients to understand how did the payback happen? What happened? Ask them directly. What happens if you don't pay me back? Because clearly you're not suing yourself, right? Because there are at least two, three projects now that I know of that are vertically integrated. There's one regional center that is the developer and the builder. But if there is a payback guarantee from the builder, that payback guarantee is between the builder and the regional center. Regional centers cannot give you a payback guarantee. Okay, so if there's any regional center out there that is maybe building, I don't know, condominiums in Florida, and they're saying, well, if this project doesn't sell out, you'll get first dibs on the condominium and we'll just deduct the 800,000 from the price of the condominium, run in the opposite direction because that is completely illegal. Okay? All right, what is the approval rate for me and my EB-5 clients? 100%. And I'm not kidding about that. You can speak to my clients, you can ask them. I have two cases where we have received RFEs. I have one I'm dealing with right now. This is a Chinese investor, and it's source of funds again because they transferred their money through Hong Kong. And so I'm dealing with that RFE, but I have 100% approval on all my EB-5s through the I-526 and at the I-829 stage. But if you work with me, you will understand why, because one of the things I send my investors is like a 15-page workbook which says these are all the documents I need from you. And so my applications tend to be about 5 inches generally of paperwork, all tabbed, all coordinated, all color coded. So it's easy for IPO to review. Okay. Do I work with EB-5AN Regional Center? Yes, amongst others. I work with EB-5AN. Jordan was just in Seattle, for those of you that may have attended his session. He was here, what was it, Thursday or Friday? So I met with him when he was here. Again, I'm regional center agnostic, which means I have somewhere between professional, good, very close relationships with different regional centers, depending on how many clients have selected that specific regional center over the last how many ever years that I've been doing this, right? I am in the last 10 years approaching or have probably crossed at this point. I probably crossed at this point 1,000 applications. So I've worked with a whole gamut of regional centers. But if the question is specifically to EB-5AN, yes, I have worked with Mike and with Jordan and Ahmed before they joined EB-5AN. So is there any difference between loan-based and equity-based for rural EB-5 programs? Yes. Again, depending on your risk appetite. Some people are of the opinion that equity-based is a little more risky, right? Because you have equity in the project. It may or may not work out. Whereas a loan-based, also the other problem with an equity is historically, there is no requirement to sell the asset or to refinance the asset within any specific time frame. So when you have equity, what you're going to want to do is always maximize for your profit, right? And so investing in an equity project raises the possibility that the partnership, because that is what is going to be created, right? It's going to be a partnership and you are a member of the partner class. But the rest of the partners may not be willing or able to exit from the project when you want them to sell, right? And so instead of selling in 5 years, they may want to hold on for year eight, because they think the market is going to be in their favor at that time. So you want to understand what the risks are between a loan model and an equity model, but that's one of the biggest risks that I have seen, and that has played out, right? So again, don't mean to sound like a parrot here, but like I said, I've been doing this since, a long time. And so one of the issues that came up around COVID, particularly around COVID, was a lot of the equity projects did not exit investors when they said they would, because COVID basically wiped out 2 years of financial performance and 2 years of financial gains that any project had, right? And so till now, we have investors that invested maybe in 2016, 2015, 2016, that have not yet received their monies back because they invested in an equity project. 2018 invested in an equity project, and the partners have decided they're not going to get the kind of returns that they wanted to see, so they're holding on to the asset, right? So that's always a risk when you go in for an equity model versus a loan model. All right, lots of really excellent questions here. But I think I've gotten through most of them. So if there are any others, feel free to put those through. It is now 1:10. If we don't have any, I will thank you all very much for joining. You have my contact information. Feel free to email me, feel free to call. I am more than happy to have one-on-one sessions with you to the extent that you're in Seattle. I'm happy to meet in person if that would help. Um, but again, thank you very much for taking time on a Sunday to be here. And let me know if I can be a resource. My team and I are always happy to help. But I don't see any other questions, so I will thank all of you for having taken the time to attend on a Sunday afternoon. Thank you very much. Bye bye.